Thank you, Mr. Chairman. I'd like to maybe give some introductory remarks and then kind of turn it over to Senator LaFleur to talk about a specific case, much of which has been discussed here. He has the facts on this, and it's much different than I think what's been characterized. Let me say, first of all, that as treasurer, all that matters to me is that we don't allow cities to unknowingly and unwittingly get into financial trouble. That's our job at the Bond Commission. And unfortunately, we can't prevent every city. We have cities now under fiscal administration, and we don't want to see more, but we may going forward. So what does the Constitution say about this? It says in the Constitution that the Bond Commission is responsible for obligations, financial obligations. It doesn't say debt, it says obligations. That includes anything that would be an obligation. Now, I do know the statute says debt, but really what Sustainability Partners in this legislation is doing is really just kind of a jujitsu on wording. We all know whether it's a lease, concession, whether it's a loan, it's all debt, and you got to pay it back with interest. Some things that were brought up that I think are interesting. The case was made that there would be less legal costs because you don't have to have bond attorneys. Well, look, there are two cities in litigation now. Another one that wants out of deals with Sustainability Partners. And make no mistake about it, this is created by Sustainability Partners, for Sustainability Partners, and it's friends. This is not, they're not other companies seeking to do this that we're aware of. This is all about Sustainability Partners doing what they want to do in terms of their goals to make money. And we at the Treasurer's Office have no objection to people making money. But we want to make sure that there's not predatory lending practices. And it appears that's what we're seeing. And you'll hear more from Mr. LaFleur in a moment about that. AG oversight. The bill that as amended in the House did not have AG oversight. All it did was ask the AG to check some boxes. And if all the boxes were checked, that was fine. There was no ultimate decision by the AG to determine whether it's debt or not. That's a massive failure. Now, Senator Reese's amendment goes a long way towards doing that, and that's great. We're happy with that. The idea of there not being obligations to the state is just not true. If these cities fail, the state must pick up on that obligation. So whatever these cities or political subdivisions do, it's important to us because ultimately the state, and it'll come to you as well, will have to bail them out if they get themselves in trouble. It also affects our bond rating, both local and state bond ratings. As you may recall, we announced recently that our bond rating actually went up, which lowers our cost of borrowing. But if we have city failures, that's going to change. So these are all important points I want to make. And look, HB 836 is designed to avoid oversight. Despite what you hear today, anybody, any common sense thinking person who reads this bill understands very quickly that it does everything it can to dodge oversight, especially from the people who are charged with oversight for financial obligations. So I want you to keep that in mind. I have a few more comments, but I would like to turn it over to Senator LaFleur if he's ready.
I am ready.
Good afternoon.
Thank you, Mr. Treasurer. Nice to meet you.
You as well.
My name is Eric LaFleur, and I'm from Ville Platte. I served in the legislature for 20 years in the House and on the Senate side. I am from Ville Platte. I have since moved to New Orleans, but I was very much involved in the transaction that you have heard about, and that is the subject of litigation. And I don't want to get into he said, she said, but I want to make it clear that a private-public partnership is not a bad thing. A 3P is not a bad thing. They're always more expensive, however, but when you measure the additional cost, you're supposed to get some bang for your buck. And so to the extent that government is sometimes, and maybe more often, inefficient than the private sector, you can enter into a private-public partnership. But you have to still scrutinize those. You have to make sure that it's cost-effective and that the deal is made clear and everybody's on the same page about the meeting of the minds between the two parties. In this particular case, the city of Ville Platte took low-interest debt, approximately 1.95. I think there was some LDH and DEQ paper. They only had 8 years remaining on that debt. 8 years. They substituted 8 years of debt and added 22 years of debt at a rate that I believe the auditor who oversees the city's finances was at about 9%. Nobody in their right mind would have done that. So it begs the question, how candid were the parties selling the product? I don't think the city council would have, if they had known in layman's terms the effective interest rate that they were paying, they would have never agreed to that. The city was also in a position at that time to use their revenue from the system to borrow money at a tax-exempt rate. And so when you get tax-exempt bonds or you get tax-exempt lease financing, you get a lower interest rate than we get in the private sector, because the entity that's loaning you the money doesn't have to pay income tax. But the government only gives that privilege to a certain few. One of them happens to be, for example, municipalities and governmental entities, as a way, I am assuming the underlying public policy is to provide a cheaper way for municipalities, political subdivisions, to carry out their mission, whether it's a sewer system, a hospital district, a recreational park, whatever the case might be. In this particular case, the city, they bypassed the cheapest way to borrow money that all of us would like to be able to get, particularly at today's rates, and jumped into a high-interest check cashing deal, basically, where you're desperate for money, and when somebody's throwing a lot of money around, you can run to that check cashing place and you'll get your money for the week. But then the next week you got to do it again, and the next week, and the next week, and then you're held in bondage, all right, but not in bonds. You're in high-interest paper that you can never get out of. And the same thing happens in these types of deals. This particular deal, not all of that. I want you to know that, because I know that the state just did a 3P for the the bridge over River Kwai. Calcasieu River, not River Kwai. Oh, I'm getting old. And of course, it was more expensive, arguably, than what it would have cost us to do it as a state. But I'm assuming that somebody weighed out the value of the state not having to come out with the $1 billion and the cost of that money and the way they were going to maintain it, and whatever the case might be. And so it worked. And we may have gotten that project on board when we may not have otherwise been able financially or maybe politically willing to do. When it comes to vital services in communities, I know everyone says, well, we're stuck. We don't have enough money to help them. They don't have enough money to help themselves. They don't have a high enough, they don't want to raise taxes. They want to raise their fees. Well, then why, if that's the case, why would you want them to jump into even a worse position by placing themselves in debt? And I realize it's arguably not debt, whatever lawyer's looking at it, but it's still a financial obligation that you must pay. You can't walk away from it. And so I know that, and Mr. Reese, my old roommate, spoke very highly of you. And Ben, I never had a chance to call you about the amendments, but I'm glad I didn't, because that would have taken several hours for us to go through those. So you may have addressed some of the concerns here, but to me, the underlying, the easiest way and the most suitable department to review is to do a financial analysis, not really a legal analysis. And that's all the Bond Commission does, is they check everybody's numbers. Can they afford it? Where's the revenue coming from? Are those numbers good? Do they have historical data? And does it meet the legal authority? They do that every month in and month out. Not to discredit the AG's office or anybody else. They charge $100 to do that. They may have to charge more if they have a lot of these applications. But again, you don't have to hire lawyers from Mamou, Ville Platte, and Chautauqua. You can just use your regular local city attorney, and it can be submitted. The contract is what it is, and just have the contract submitted to the State Bond Commission, and they can review it, and it would be very simple for $100, although you might have to charge more. But in any event, this is a catastrophe. The city now is at the Bond Commission, and the reason I came today is because the city officials are coming later in the week, but we now have to go into the marketplace and borrow money to pay off this high interest rate financial obligation. Today the rates are higher than they were ordinarily, and we bypassed what municipalities get in line for, which is LDH and DEQ revolving funds. You get in line for that, you got to wait. Sometimes it's not enough. You plan it out. We got in line, we got it, and we just gave it up because we had a peddler in town that was able to push a bill of goods that sounded too good to be true, and it was too good to be true. And to the extent that we need a check on anybody, including ourselves, it seems like going through the Bond Commission, a quick analysis would have demonstrated what the auditor was clearly able to demonstrate, that if you looked at it on the payout, you went from paying a couple of points for 8 years, and then you're paying, I think they calculated 8 or 9% for 30 years, actually. For 30 years. How do you think the city of Ville Platte's ever going to get ahead? And the only way they can get ahead, by the way, is to do what they never wanted to do to begin with, which is to raise taxes or raise their fees, because these guys are not going to wait for their money. Essentially, at some point, they're going to have to raise their rates. And if they raise their rates, the net revenue of the system, which typically provides, is a profit center for the municipalities. If I don't know where everybody's from, but that's the profits from the water and gas and utility system that oftentimes goes to pay the fire department and the police protection and all the other vital services. So you're selling a vital service and giving it away. But the damage is long term, much more than that, because those net revenue producers, as a business enterprise, the profits you made, they go somewhere else. And like I said, I don't think 3Ps are bad, and they can be good, but not this one. They're very unique in where they can make a difference, and clearly they made a difference here, but very much to the detriment of the taxpayers and the ratepayers in the city of Ville Platte. And, I know Mr. Scametta was here today. They're not subject to the PSC on their rates. So if they have to go higher with them, they just go higher. So they could be much more prudent if the State Bond Commission would have the opportunity to do what they do every month, inexpensive review, and it adds 1 month to the process. So
we have a few questions for you. Senator Luna.
Thank you, Mr. Chairman. All right, so what I'm looking at today is a 5-page bill, 3 pages of amendments, 9 pages of explanation, and 4 pages of photographs on what's clearly a complex issue. I wish this bill would have been brought to us sooner in this process, because I have some concerns, because it does have a dual referment. It's going to have to go to finance, although it's just barely in there. But I have some concerns about the timing of how this would all work. But my concerns are much greater for what's happening, what would happen in this bill. The first thing is, when the state of Louisiana has had serious complications and problems with arbitration, when we unwittingly, on a last-minute amendment that got put on a bill, we ended up, all of our universities got hit by hurricanes arbitrating in New York. We just can't have that kind of stuff. And arbitration is typically works well for the people who are aligned with the arbitrators who normally come from industry. So that's not a good thing for us. Whether this is a debt or an obligation, I don't care. It's a duck. It's quacking. We all know what it is. That's a play on words trying to get around a constitutional provision, which is contrary to everything we do. Clearly, the Bond Commission is who should do this. I've served on the Bond Commission with you, Senator LaFleur, and that's what they do, and they're very good at it. And they pick this stuff to death, and they go through it, and they give us good information where we can vote on whether to do something. I can't imagine why we would remove that from that entity and send it to the AG's office, who is already burdened with a lot of work, to have them ramp up and do the same thing the Bond Commission's already doing. It's nonsensical to do that. What I'm going to suggest is that we defer this bill for 1 week to give us all time to go through this, to look at the amendments and see if the amendments correct enough of the problems to where it makes it viable. Because honestly, in its current position, I don't think this is what we need. But I do want to give the amendments a chance. So, Mr. Chairman, at the appropriate time, that's what the motion that I would like to make.
Okay, let's hold that motion until we get to the appropriate time. Thank you, Senator Luna. I have no further questions at this time. Do you have anything further?
Well, I would just like to mention a couple of things. Number one, relative to Ville Platte, we actually asked them to calculate it, and they said in present-day value, it approaches $8 million they're losing out of this, going from debt to whatever this lease agreement is, back to debt. There's a net loss of $8 million in that process. So it is measurable, the damage that's being done. I'll also point out there's another lawsuit with Sustainability Partners. That's a Capital Area Groundwater Conservation District. And as a result of that, they're going to see the cost of the pump fee go from $20 per million gallons to $65 per million gallons. And there's another city that wants out of this deal, their deal. I can't mention them at the moment. But the point being here is these deals are not going well. People feel like they've been hoodwinked, and they want out of these deals. They look much more like payday loans or subprime loans than they do real, obligations in terms of bonds and interest rates and things that we normally deal in. And again, as chairman of the Bond Commission, treasurer, I'm not looking for more work or responsibility. I just want to make sure that I do my job, and I do it well, and I do it with the resources I have. And I just think if we break loose and have a whole nother segment of activity that is debt, any way you want to look at it, that isn't under any kind of oversight, I think is a huge mistake for our state. So thank you very much for hearing.
Thank you. If y'all hold tight, we have a question by Senator Morris.
Thank you, Mr. Chairman. I would like to ask whether you are aware whether there have been any federal investigations. Has anyone contacted either of you from the SEC or the U.S. Attorney's Office or any of the regulatory agencies, CFPB even? Either of you?
Yep. I spent about an hour and a half at the Securities and Exchange Commission regarding this transaction. I can't discuss what I discussed with them, but I did. I can.
Did they reach out to you, or did you reach out to them?
I don't remember now.
Okay.
But yeah, they have contacted me at least 3 times.
I see.
And I've been told by another individual, but I can't name this person because they didn't give me permission, that they have been in conversation with the SEC as well.
I see. Okay. And you can't elaborate any on what the nature of the issue was?
It's all secondhand information. Well, it has to do with giving financial advice and being certified and able to do that, being a fiduciary or whatever those responsibilities are, that there are people there are lawyers, in fact, that feel like that the people giving advice were not qualified to give that advice and may have actually been, doing it out of their own personal interest rather than the client.
I see. Okay. Thank you.
Thank you, Senator Morris. Okay, the board is clear.